Morning, afternoon, or evening. This is Stephanie Joy with Joy Disability. You're about to see a replay of the live Q&A of a recent session. They are generally 1 to 2 hours long every Wednesday at 1 p.m. Eastern Standard Time on this YouTube channel. So I hope you get a little tidbit of information out of it. Otherwise, maybe I'll see you at 9 a.m. for short little workday shares that we put out there on a daily basis. Take care. Hey all, how are you guys? I think we have a guest today. Some of you might remember Shanna Justice. What a name, right? For Social Security Disability Representative. She will be here shortly. I didn't get a chance to speak to her beforehand, so hopefully she'll just pop right in. All right, I think she's... Give me the wave-o, Shanna. You ready? Okay. Ta-da! All right, let's get to comments. Okay. For those of you who have not met Shanna, Shanna is a representative out of Kentucky, right, Shanna?
Yeah.
You want to introduce yourself?
Shanna Justice, non-attorney representative. I only do Social Security disability claims, and I do them in all states, but I'm based in Kentucky.
Sounds good. Sounds like me, except I'm based in Pennsylvania. And pseudo Jersey, I suppose. All right, so we have, I don't know if you can see the comments, Shanna. I don't know if you see what I see, but I pop them up on the screen anyway. But I see that just a few people here nice and early. Wes Anderson with the first question. He'll be first. Virginia Gomez has popped in. Beth Prince. These are all people I know. Colette Shumpert. I don't think I've met you yet, have I? And forgive me if I have. Sometimes I get a little brain farty about the teams. But here we go. Let's go with Wes. Wes, I think we have met before. So here you meet Shanna also. So Wes says, I am in step 3 of reconsideration. My medical review went to federal quality review. Okay, we've had a lot of these lately, Shanna. I don't know if it's new messaging by the SSA when this happens or what, but people talk about it a lot on here. And I even had a few in my caseload where never would I have seen that before. And that doesn't mean it doesn't happen, but it just seems like it's more transparent now. Anyway, he says that they looked at it and sent it back to DDS. DDS told me they are re-examining it. Good or bad? Why? I have my thoughts on it. Shanna, do you have any thoughts on that, or do you want me to just take off with it?
Go ahead.
Okay. And I first just wanted to see. I wanted to make sure before I think. Okay. So Colette is letting me know that you guys have heard me. Usually before I start, like when I start, Shanna, I'm like, can you guys hear me? I want to make sure I pressed all my buttons because they all know I'm not the most techie person in the world. And you should have seen me 2 minutes before we started, actually about 60 seconds. My green screen fell over twice. And I'm like, what's going on? I forgot to put the little feedies out that help stabilize it. All right, so that's me. All right, so Wes, federal quality review. I know we've talked about this lately with a lot of you. And again, some of mine. That's, I believe, that random audit that has always existed where a DDS adjudicator's determination, technically, I believe it could be either way, but I get the suspicion it's more with when the adjudicator wants to award. And there's a set number that they pull to make sure that the DDS adjudicators are following the federal laws of the steps they need to take before they can make that determination. So the fact that you got one and you've been told it went back to DDS tells me that suggests to me that the auditors, federal quality review, found something that the adjudicator didn't touch on enough, perhaps, whether he missed a whole step or just didn't touch on something enough, and they sent it back for them to do that. I have seen that before, one time with one of my clients, and this is before it became an announced event. And I suppose it's okay that they announce it to people. It was because they felt that the person had not developed past relevant work, that 5-year period. Although this might have been even when it was a 15-year period. It might have been last year that early. And they just had to go through and get more details about that past relevant work, which was really important because it would, as you know, with the grids, your past relevant work and whether you can do your prior job or transfer skills from that job are 2 of the 3 prongs of a grid out. So it was really, really important. They're probably not going to do that for someone under 50 without a potential grid out, because if there's past relevant work at step 4, and then at step 5 is, well, is there any other work? If they already know there's other jobs in the economy that you could do based on the RFC they've applied to you, it doesn't matter what they figure at step 4 because you'd be losing at step 5. So sometimes we'll see in a determination, particularly in the DDE, disability determination explanation, that we get later, although now we're supposed to be getting them now, but there has been a little glitch. They will say the question about transferable skills, they'll say not relevant, or I forget how they word it, but it's something to the effect that you could tell they're saying we don't have to worry about the old job and whether he could do it. Yeah, it's the old job and whether he could do it because there's other jobs in the economy, blah, blah, blah. But Wes, so I think, there's a good chance they pulled it for you because the adjudicator wanted to award. That isn't a certainty, but I feel like that's a likelihood. And then usually the DDS person tries to get the information to support his original his original position. So I don't know if he's contacted you to find anything out, or that he was missing, or what's going on behind the scenes. So we don't know what the particular issue was, but I think that's, kind of typical. Anything you think about with that, Shanna?
No, it looks like further down he says he's 59 and working the same job for 25 years with a GED in some college, though.
Yeah, so they're it could be, it doesn't have to be a work-related thing. It could be something completely different. It could be medical. But obviously, Wes, that at 59, you're in the highest, pretty much the highest grid allowance area there is.
Yeah.
But people do lose at 59 all the time when they don't have the goods. So they're just making sure those goods are there. And fingers crossed for you, Wes, that you come out smooth sailing on this one. Virginia, kind to say that you just wanted to say good morning and keep up the great help you're giving. May God bless you and have a great one. And you too as well, Virginia, and everybody. Virginia goes on to say that on an outcome appeals counsel, how long is the wait time in California of making a decision? Thank you. Would you like to give your thoughts on that, Shanna?
It's here and there. You never know with those. I think the ones I've got recently have been about a year or so, unfortunately.
I agree, and I think it's definitely hit or miss, like Shanna said. I have seen, and I don't think it's related to your state because it's the appeals council, and that's more of a team up at the federal level, not really state oriented. But I think, and it is interesting, different cases in the same year, I could have one, they make their decision within 2-3 months, and then another one, we're on month 14. So I don't think there's rhyme or reason that we can see. They probably have their reasons, whether it's a more difficult case or maybe someone the adjudicator, it's not an adjudicator, it's like the workup people on that. I don't know what the word is off the top of my head. Maybe someone left, who knows, something got hung up, but they wait because we can see the status now, right, Shanna, in the status reports that we get, that we didn't have this a couple of years ago, guys. And it'll say awaiting and I forget the verbiage, Shanna, like awaiting the people that are going to be reviewing it.
Yeah.
Or it's currently being worked up.
Or assigned to analyst or assigned to adjudicator and things like that.
That's right. Beth Prince says, happy Wednesday hump day. Back at you, Beth. Colette again says hello. And I think she might have a question down below. I'm not sure. Okay. So I don't know if we got to this part. My medical determination was selected for, yes. Okay. So we addressed Wes, I believe, right, Wes? Umo, good to see you. And he says, hi, Shanna.
All right.
Umo. And you can see all these, right, Shanna? These are just hellos.
Yeah.
La Lulu. Let's see. Kevin Johnson asks, can I get an OTR decision and not see the ALJ? Would you care to opine or shall I?
It's possible. It just depends on, your medical treatment and, that they have all the medical treatment and you've had what's needed for that. And the judge doesn't need any more additional information.
Yeah, I agree. The OTR, for everyone who doesn't know what that means, that's on the record. So sometimes they do that sua sponte, which means they grab it themselves. Usually, my understanding is that in a perfect world, you appeal to the ALJ, their attorney advisors are reviewing every case that comes in the door to see if it could be an OTR. The vast majority, it's like winning a lottery ticket. To get an OTR, they will bypass. Now, I've had that happen, and this is very rare, that this would happen, that I would request an OTR, and and get it. I have requested an OTR, if it's not been automatically done by the team working on it and the judge. And once in a blue moon we get them, but usually the ones I find that usually it's the ones that happen in earlier on. Maybe I have to check something. I think my tortoise is trying to knock down my green screen. I think maybe he thinks it's food. This is not good. Then you could take over, Shanna. I'll see how he does. He tips it over or eats it. But anyway, so yeah, it happens. It's just not that common, Ken. So, it's got to be such a slam dunk case without question. It is really an intense kind of case. So for what that's worth. So Colette says, okay. So Colette says that she hasn't been here before, but she's looking at the replays and they brought her here. Oh, I'm so glad you came. That's awesome. All right. Scrolling down. Art of practice. Okay. Are you practicing law? Art, I wonder, because you ask about attorneys, you might be one yourself, right? He or she asks, do attorneys now have access to the disability determination explanation document via the ERE expansion that was supposed to be released on June 7th? Thanks. Shanna, I had kind of announced this to my people that, watch my channel, that it was coming out because I'd gotten the NOSCR message. I don't know if you got it a little in advance. And I was so excited. It was like a week before they announced it, like it was happening in a week. It was fabulous. It wasn't like we had to wait 6 months. But I have found all the sections show up but I'm not seeing so if I'm in beginning of recon and I go in there, I should be seeing the initial the DDE that denied on initial, and they're not in there. Have you had this opportunity yet, Shanna?
Was in there yesterday and playing around, and it looks like I don't notice anything different or more than what was there before necessarily.
Well, there was remember we had E and F.
Yeah, I know there's more sections, but
okay,
I don't.
You see the sections, but you don't know.
Any different than they were before for that part though.
Well, okay, so what I'm finding is the sections are there that they said were going to be there. A and B are added. B has I think a copy of the letter that they sent to the claimant. Duh, we already have this. It was sent to us too, saying you're denied. And I got to check that, tortoise. You're denied, blah, blah, blah. But they don't, that canned little letter that says nothing. And that's it. But section A is what would have the DDE, and that's empty. So I did reach out to NOSCR. And Jennifer, I think her last name is Cronenberg. I've seen her in some of the seminars and visual announcements. She responded to me, which was very kind, and said, it seems like it's for, it's touch and go. Some are seeing it, some are not. They are aware of it, meaning SSA, and they are working on it. So it's probably like most everything else. There's going to be those little glitches, and, in time, it will come about, I suppose. I kind of expected that. And they even said, we're doing this beta. I think it was a beta of this, and it'll be great and blah, blah, blah. I think it'll be fixed.
Those would come in handy to just be able to see early on.
Yeah, absolutely. I think I did get to see one but it was where, and I'm not even sure, but this is what I feel like I saw, because at the time I didn't realize there was going to be a glitch, so I didn't pay attention to what was working. One that got denied on recon, and we have to appeal to ALJ, but that hasn't happened yet. Suddenly it's in there. Recon, it's for that one, not the ones that are at an earlier stage. Are you able to click on or read a question and answer it if I turn on and look at this?
I'm able to read them, but I'm not able to click on them or anything.
All right. Do you want to just grab one and I'll be right in because I'm like, I just got to make sure this guy isn't going to, he's not that big, but all right.
Looks like Colette.
Yeah.
Can she get a part-time job? She applied for SSDI and she was fired from a part-time job due to disability and a 2-year treatment plan, and unable to work a full-time and not sure if she can work part-time. You can work while applying and after if it's under it's not full-time and less than, I always tell everyone it's $1,500 a month. Probably it's actually a little bit more than that, but I'd rather you stay under it, well under it, than have to worry about coming too close and them cutting you off just because. But yes, you can.
I agree. I agree 100%. Yep. And I think it's great when people do that need it. Some people, are unaware. I get the fear of risk. Everyone's got their own risk tolerances, but I do love it when people feel well enough to put in a few hours a week and make that extra money. Sometimes it's enough to all they have to do is meet their mortgage, and that's all they need to meet because they have. And I just think it's great. But yeah, just follow those rules that, some of what Shanna just spoke about. And I do agree. Should we touch on, given that when she says, I'm unable to work full time, but what if someone was wondering if they could work full time because they found this great opportunity? We could touch on, if you guys want, what the unsuccessful work attempt is, right? So there's a lot of nuances to it in terms of you can't go on long. You have to fail at it in the end. And you have to fail because of your disabilities, not because you decided to be a stay-at-home mom suddenly. If you definitely have to be under 6 months, and it's kind of generally a very bright line rule, not 6 months in a week or a day, it's 6 months. And if you are doing that full-time over SGA work, any kind of over SGA work, and the adjudicator learns of it, which technically you're supposed to tell them, they're going to deny you because now they're going to find that you failed at step 1. Is she working SGA? So it's a tricky little maneuver to do. And if they do, by the way, you just appeal, because then, if you fail, at least you kept your case alive, And a reminder that if that happens and you still win your case, which this happens all the time, those are nothing burgers to me if they come up in a case. They don't make you pay back the money you earned, and you're still going to get your SSD for those months, because they were considered disabled and it was a failed work attempt. So the incentive is there to try. And that's what the SSA tries to give you, I think. Some people think it's a trick. They're trying to trick you. I'm like, well, no, it's like, if you can do it, it's not a trick. It's I don't know. Anywho, okay. Wes wants to know, going back to the FQR, RFK, no. How long do they have it? It's usually not long. They're trying to get off their plate, but there is no bright line rule for that. Just like there's no deadlines at all, from an official point of view of how long a DDS takes to make the decision at all. This would apply to that, but I'm pretty sure they have a grand incentive to, get it going. Shanna, your thoughts?
I agree.
Yeah. Darren, I would like to hire you. Well, if you want to hire either one of us, we both have our protocols. I think you guys all know mine. You fill out that evaluation form. If you already did that and we're already talking, or you've communicated with one of my assistants, then that's moving in that direction, or whatever's going on. But, if you go to joydisability.com, in the upper left is a link for the free SSD evaluation you can fill out. And that'll get you at least, knowing whether this could happen. Shanna, how about you?
They can call the office, email, or text us for a phone call. I basically take any case that's at the moment. That may change, later, but as of right now, any case that I know with the proper workup, we can get approved, and basically we'll work with anybody at the moment. I'm able to do that.
Awesome. Do you want to give your website?
Yeah, and reach out through justicedisability.com. Like I said, call the office, and the number's on there, the email address is on there, or there's even a contact form on the website. And we'll reach out to you or email you or whatever and see what's going on and how we can help.
Perfect. Okay, Darren says he left me a couple messages on my, oh, you mean my 201 number, not 202. Is that DC? Or is that 212? Or is that New York? I don't know. Oh, yeah, 201. Oh. Okay. Messages, voicemail. I thought there is a Darren we've been communicating with. I think we can get back. So we'll see about that, Darren. No worries. Shub. This is Shub, not Shub, Shanna, just so you know. And Shub prevailed and got his first check on Monday. I forget, Shub, how long ago you... Phone's going off. Okay. And M. Williams... Oops. Shanna M. Williams is not one of mine, just someone who shares time with us here. But he, sorry about that, prevailed recently after Daryl Hall. So he was good to share that with us. And he'd been here long before he prevailed, and he's still here. So it's really nice to keep seeing you there, M. Williams. Umo, this is about your own private case there, Umo. Now that you got my AC appeal dismissed, yeah. Is there any time frame that occurs to show it's closed for sure? Yeah, we got the order. We got the order, Umo. So check your portal. It's in there. And then we'll be moving forward. Okay. Mr. P. Mr. P says, I'm applying for SSDI while working part-time. I was denied SSI last year. Would quitting my job look bad, or should I try to work until a decision? I'm always thinking about quitting. Really can do it. Really can do it or really can't do it. Don't know if that's a typo or not. Quitting your job doesn't look bad, but it's not necessarily going to get you to win either. What do you think, Shanna?
I mean, I'm a little confused on it. If he's got an active SSDI claim pending, the SSI part may not have had anything to do with him working. It may have been an assets thing, because that's for people, you can have one thing, that kind of thing. So as long as he's staying under the not working full time and staying under their SGA, it's not going to working or not working. It's not going to affect him.
Yeah, I just totally blew through that with my poor eyes. SSD versus SSI. I just thought he was saying I was denied SSDI last year, even though I probably didn't read it that way. Yeah, so you're talking about two different things here, Mr. P. You would be denied SSI if you were making, on the financial level, if you were making, I don't know what the amount is, it like $1,800 right now? If you're making $1,800, you're beyond SSI. Not to mention beyond SGA separately. You know what I'm talking about? Like when they do the dollar for dollar offset, the $2, $1 for every $2 offset, it takes that much to get all of your SSI wiped out. But so if you're denied SSI, that could have, you don't know whether that's financial denial, like they didn't even work you up. Was it also an SSDI case? Was it concurrent? You say now you're applying for SSDI, and sounds like didn't apply for SSI again. Would quitting my job look bad? No, but it's not going to, you either have the medical evidence or you don't. And if you're not working SGA, now you're part-time, a lot of times part-time is over SGA because people aren't.
Can be, yeah.
So you got to be really careful. I mean, whether you should quit or not really depends on, I think, how you feel. I mean, if you have no problem working and you like the cash, savings for a rainy day, it can be a good thing, right? So, we don't really know enough of your details, Mr. P, but Maeve, good to see you, Maeve. Don't you love her little squigglies here on her name? So cool. I love, my menagerie. She says, I love SJ's, Stephanie Joy's menagerie. I also had one. Dogs, cats, parrots, frogs, turtles. It's awesome living in a zoo. I do live in a zoo and can't wait to not live in a zoo, to tell you. I'm aging out of this whole, it's a lot of work. And 90% of them are not mine. So, but kids don't always take care of their stuff, and the parents, it falls on the parents. So there is that. But one of these days I'm going to get the parrot, one or other of the parrots up here, the conures, the little minis. Tony P. How do I get new medical records? How do I get new medical records to the SSA? They approved medical and sent my file back to field office. They sent it back on May 7th, went online. They said, you don't get new medical records to the SSA after you prevail. Agree or disagree?
You're done. You just got to hang tight and wait for it.
Yeah, don't rock that boat. You know what I mean? All you need is to have one of those medical records say, he's doing great. Yeah, no, you're good. If you've already been approved medically, cut it off and then just have patience. Okay? That's awesome, by the way, Tony P. Yay. You're saying, can I still submit? Why would you? You got them where you want them. You add more, it could go negative. You don't know. What you think is looking bad in a medical record, and not to mention, they're not looking at it anymore. It's no longer at the DDS. That's the only place that looks at your medical records. It is not there. You don't have a medical case workup anymore. You want it. Don't look a gift horse in the mouth. Leave it alone. And by the way, you don't send medical records in, and this might be the confusion. Maybe you think you're supposed to be keeping it up to date for CDR purposes later. You keep all that stuff behind the scenes. You keep treating to the reasonable extent you must, but you're not sending those into the SSA. If you get a CDR, they will tell you what to do. They don't want your paperwork in the middle. You're Free beneficiary, able to live your life. Art of the practice says, I'm not an attorney, just looking for helpful info at the reconsideration stage. And the DD, oh my gosh, that tortoise. I might have to put him in a box or something. And the DDE that you mentioned would be helpful. I know. You can probably, Art, call your field office and say, I need a copy of my DDE, and they should be able to get it to you. They might ask for that 3288. They are complete. Oh my goodness. Hold on. You can keep talking. All right, fine. You want to come hang? You can come hang, but you're going to ruin my stuff. This is Fiona. She's a super honey. I'll not be part of my, can you see? She's really super sweet. Watch her pull her head and watch. Oh, maybe not. Who's that up there? So is that Shanna? Please stay where you're supposed to stay. All right? You got a whole room to wander. She's got a whole room to wander with a water bowl that she can practically sit in. Heat lights. You've got a maid. I don't have that. Yeah. You can Art, you can call them and see if they'll be kind enough to do it. I mean, it's just one document. It's like, but if they don't, they might say, you have to order that officially with the 3288. And I just shared one of my 3288s with my attached stuff that says they can't make you pick and choose what you want. Now, you only want your DDE, but you could ask for your entire file. And they'd have to give it to you. So, and they have to email it to you if you want it emailed. They will tell you otherwise, and they might try to get $100 out of you. That's not legal. Anyway, I have a generic that I share when someone asks, email me with my little additional comments. It's generic in that you can put your own stuff in there, but it has like the attached palms. It says you can't make them. If they say they want the whole file, you got to give it to them. And it also says, here's how you email it to them. No, they don't need a CD. Who wants a CD? It's ridiculous. All right. Lily says, hi, Lily. Have we met? I don't know that we have. How long does a federal quality review? See all these federal quality review questions, Shanna. I hear this out the wazoo now. Thanks to being here with this, because they're telling them now, which is fine. Yeah. Really. Can this be a reversal or a denial? Is this common? Thanks. Yes and yes. And yes. Yes. Yes, it can be a reversal. Yes, it can be a denial. And yes, it's kind of common now. I don't know if it's more common or if they're just being transparent about it. They're telling them. It came out of the DDS. It went for federal quality review. I remember years ago reading that it was 13%. And then I see other numbers floating around in latter days, and I don't know what's really accurate, but like 13% would get pulled back in the day. Oh, I don't know what you think about this, Shanna. Wes says, what about all the places, sedentary jobs that refuse to hire me due to all my medical issues? I would rather work. I just can't. I have a kind of a tangential thought on that, and I wonder what you think, Shanna. I tell people, you don't have to tell people your private medical business. What are you going to a job saying, I want the job, but don't hire me because I have a bad back and it's going to be aching within 2 hours of sitting at your desk? Not their business. If you want to try that job, you try it. I mean, if they say, is there any reason why you can't do it? Well, that's probably not something you can't do. You have it. We all have medical issues of some kind. All of us. Some of us more minor than others, obviously. But we don't go tell people. It's not their business. It's either, if you think you can try to do the job part-time or whatever, then you do it. But a lot of people say, well, every time I tell them my medical problems, they don't hire me. I'm like, if I told people my medical problems, they'd not hire me either. I mean, that's just, you don't have to do that. It's medical privacy. Unless you're going to be a pilot where you have to, being physically fit as a fiddle, like an Adonis, is kind of part of the job, not having severe heart issues and epilepsy, or driving a bus, CDL. Most jobs do not have a right to know. Agree or disagree? Or any other thoughts or, ways to...
Yeah. It's none of their business unless they can physically look at you and tell. They're not going to know what problems that you suffer from, and you have no responsibility to tell them. You let them hire you, and if you can't do the job, you'll find out real quick, and they will too. But it's nothing to tell them up front.
That's right. It's not like you're getting engaged to somebody and you really should tell them problems. Hey, Jen Me, I haven't seen you in a while, lady. He says, yeah, but in playing this SSDI game, I've heard many times that SSA basically punishes you more often than not for working at all while applying. That's never happened to any of my clients, so I can't speak to that. Will they hop on it and use it against you? No, it's never happened to any of my clients that work part-time in 21 years.
They have to go by the rules and regulations at each stage and each level. And it says that they can use that as a basis for denials.
I mean, remember too, are you working a job that belies the claimed disabilities that you have on, not you, Jen, me, but, somebody, if they say, and I always use this very wild example, you have a bad back, you take a part-time job, it's under SGA, but you're baling hay on a farm, or you're a lumberjack, part-time under SGA. Yeah. No, that's going to definitely show that you don't even think you have bad back problems. So why would they? And that you physically don't, because you're able to do that job. So I think the people that have perceived that really don't. I'm not kidding. That tortoise is going to eat up this office, but she's not eating. She's like obsessed with that. And it's big. It's like a big wall behind me. It's so funny. Yeah. That I think is untrue, Jenny. It's just people's perception because they are not following some of the common sense that would be inherent in working while having a claim. So if you have two different inconsistent things, it could be as simple as I can't be on my feet 4 hours a day, even out of 8. And then they have a job on their feet in 5-hour shifts. It's not that wouldn't be disabling, but now they have a credibility problem because they said one thing and they did another. So, and the credibility comes into it. Kevin Johnson, he says the adjudicator didn't even know what the grid rules are. Actually, he or she probably did. She probably just didn't know the nickname to it. It's called something else, and they go through it in a different fashion. It's not like with all these little, now I'm doing the grid rules when they get to the areas they get to where they have to consider the age. So I don't think that's true. Now, granted, some of them, over the last several years have been very new. With the Great Resignation, we lost a lot of seasoned adjudicators, and they might not be as well trained, but I don't think that's so. Thoughts, Shanna?
I agree.
So to go through the steps include them. So
yeah.
Umo talks about the AC appeal dismissal. You are so welcome. Anthony says, I was approved for SSDI and my first check is next month. I am making payments on an overpayment on the Social Security survivor's check. Will they take my SSDI lump sum? They may. I mean, you apparently had an overpayment for whatever reason. And I guess you haven't appealed it or refuted it. Can't really say how they're going to do that. If you don't want them to, it never hurts to ask. I can't say that they wouldn't listen and say, hey, but I tend to think back payments, they probably will use it's better than taking forward payments for an overpayment. Like they might take the back benefit lump sum. Thoughts, Shanna?
Yeah, I figured they usually do withhold that and apply it to that if there's an overpayment.
Because we have various debts we all want to pay with our back benefits. But which takes precedence? Your credit card, and I'm not saying you, Anthony, I have a credit card debt, I'm not saying, but just by way of example, or the Social Security fund. Which one should be more important to be paid back? From a kind of a universal standpoint, the federal government debt.
Yeah, they basically already have your money for that, so they're not going to risk giving it to you to not get it back.
Right. Do you want to start this one, Shanna? I got to check on the turtle, and I'm going to have to.
For a CE, and the report says sitting max of 2 hours, standing for 1 hour, needs a cane and limited arm mobility, and almost 60 years old. You're already at a good age, minus all that stuff, have a good chance. But with those things in there, as long as your medical records support that as well, if you were denied. Those are definitely good. That's a good report.
Yeah, that sounds really good. I agree. I'm just reading it. I just had my daughter put the tortoise in the bathtub because he's just like, or she, I should say she's just really curious about everything. All right. Shub says that was good. And I hope you prevail, Lily. It sounds good. Okay. So Shub said it took 70 working days for approval. So he was really fast. Now I'm bored. Thanks for remembering me, Shub. I can't help it. It rhymes with something. So I don't know. It was easy to remember after you told me how to pronounce it. Speaking of something that rhymes, I had a Facebook post that someone put. It was a big sign that some work crew on a highway had put. I think it was work crew on a highway. It was a light up sign. It might have been an advertisement sign. I'm not sure. But all it had was the word that rhymes with shoe on it. I thought it was hysterical because once they figured it out, they had to yank it down because someone had gotten in and hacked, I guess, the department electronic signs on the highway, and it just said the word that rhymes with shoe right up there for all the world to see. I thought it was really fun. Those things don't offend me; they make me laugh. But okay.
Yeah.
LC, hi LC. During recon, when you get a letter from DDS examiner to contact you within a week, but they never call you back. This is not unusual. What does DDS examiner want? And if they do not call back, what happens after that? Do you want to take that one?
I would call them back again and let them know when you leave the message that you have left one before, because they've got, if I'm not mistaken, they told me they have 48 hours to return calls like that, and they can get in trouble for not responding. What's the point of sending the letter out for you to actually respond and then them not to take the call?
Yeah. I had an incident this week. I think I might have even shared it to these guys. Same letter. I think this happened with 2 different people this week. And you call back and you get their voicemail. And so what I leave on their voicemail, because I call, for some of us, we don't have our clients call, everyone's different, but I don't have my clients call back the DDS. I tell them to let it go to voicemail, give me the contact information. I'm going to call for you. And I leave the message and I say, hey, if you call back, can you leave the information about what you want? And I will be sure to get it to you. And we won't have to play this phone tag. Or if you prefer it in writing, you can fax it to blah, blah, blah. Then we don't have to wait 3 weeks for my mail to get here. I've seen them leave multiple messages with the same nonsensical, just call me back. I need to ask questions. Lay out your questions. Why are you so inefficient? It's ridiculous, because then, like if she had told LC what what the adjudicator needed, when LC called back, LC could have left that information. Or if it's a document they wanted, could have, faxed her the document or whatever, and it would all be done. Like they would have what they wanted. So it's a little weird, a little inefficient. But yes, I would do exactly what Shanna does, call him back and then explain that you already called before. And then maybe say, if you call me back, can you please let me know what questions you have? And, we can, if we're going to play phone tag, I can get you the information via message. Lily is in stage 3 and says her U.S. senator was very responsive and supportive. Not sure what you contacted them about, but that's great. Williams is sharing that. Oh, that's sweet. Okay. Dimple, hello from Ohio. Good to see you, Dimple. You're late to the day, Dimple. Just kidding. Oh, Shoob. Gifted 20 memberships. So the funny thing is, and that's awesome, that'll be like 20 extra people, members, for the whole month. And they get whatever, the early access to certain videos and stuff like that. And some other little attentions. It's like a benefactor thing, Shanna. Okay. Maeve says, thank you, Shoob. I'm thinking you gave her a membership. That's really sweet. Mr. P says, yeah, I was denied SSI. I reapplied now. I only qualify for SSDI. That's financial. Okay, that's fine. It's a risk for me to quit, but every day I want to quit. I hope I can win this time. Well, you have to be under SGA, so make sure you're under SGA. And as Shanna, I think you said before, don't flirt so much with the line of SGA because tip you over.
Yeah, I know the cutoff is like a lot higher. Well, not a lot higher, but a little higher than what I tell my clients. But under 1,500, we don't want to go any higher. Just to be on the safe side.
Yep. And part of
that,
Yeah, part of the reason, like sometimes people get raises and they don't even think about it. They don't mention it, and now they're over SGA. They didn't think about not taking that extra shift or two, and then you have all these months that are SGA here and there. Wayne. Hi, Wayne. Wayne is 53 and has been in SSDI process for 7 months. Have diagnosis of severe cervical stenosis, degenerative disc disease, and lumbar herniated disc 4. Surgeon visits upcoming, ACDF failed epidural cervical injection. So you're going to have a surgery, ACDF. Okay. Well, doesn't sound like the worst case ever. You are over 50. That's helpful. So, and it's funny because we really want that surgery to rate you again, right? We want you to be fit as a fiddle, right? And feel good. And hopefully that's the case and you don't have to worry about any of this. But sometimes there's a bit of recovery and stuff like that. So if you do recover really well, it could be a closed period of disability. So that's out there also, which means you get some, but then I've had a case or two where someone, well, they went back to work, and so there was a closed period of disability, and the same thing can happen if you've already had your surgery and they find that it did, then you had PT and stuff like that, and then after a few months of PT, they think you could do light work, which is more than sedentary, which is, would mean that you're not disabled. Beth says, Fiona is gorgeous. She is, and she's so sweet. We've had her a really long time. She had a boyfriend named Cecil, but he passed away years ago. He was actually the original. Okay. All right. Everyone's being very thankful, Shub. You've been so generous, and that is very generous. So Wayne is saying that he's seeking a second opinion. He's doing physical therapy and is an MRI referral. So you're getting a second opinion on whether to have that surgery, Wayne? I think that's never a bad idea with surgeries. There's always a risk with surgeries of great magnitude, even if it's a small risk. And then there's other risks that are greater. And there's also the risk that it doesn't work. So yeah, I think that's a good idea. What do you think, Shanna?
Yeah, I agree. Does it hurt?
The West says that he thought we had to divulge our restrictions to a place we go to work. Not really. They're not, there's no law, right? Do you have to divulge it to your grocer when you go in there to buy food? You don't have to tell them private business, What if you had some STD? Do you have to tell them that? No. You don't have to tell people your business. Yeah, and he's saying, as you alluded to, Shanna, they can look at me and see I have problems. That could be, but if you're, maybe you walk with a limp, that would be an obvious one. Sometimes people think they look like they have problems, and people just say, no, it's just a middle-aged person. We don't walk, none of us walk like we did when we were 20, or many of us anyway, unless maybe just the personal trainer ones. But seeing that you have problems might just mean, thank God we have him in a sedentary job, because I don't think he could go do the construction work that's going on out back. Do you see what I'm saying? You don't have to divulge stuff. No one's going to hire you with that. You're just sabotaging yourself. Jen Me says, well, we are saying they have to go by the rules and regulations, but reality is that I know that my ALJ did not in fact follow those, and even the federal judge perplexed, hence why it was remanded. Yes, they do make mistakes, Jen. Absolutely. They're human, like we all do. That's what those appeals are for, right? Yeah. But I will say, I don't want to say 99%. What would be the percent that doesn't make a legal mistake? You might disagree with their finding, but they followed the rules to come to their conclusion. And that's probably 90%, an A minus. I don't know. But if the appeals council remands, this is a few years ago, I think 15%, and then those go back. But then I don't know, probably a lot of them get denied anyway, because the remand was on a technicality. The judge cured the technicality and then was able to support a denial. So what percentage is the kind that's remanded and the judge changes? Now, I will say that I believe on every remand it's been flipped over and the judge awarded us, same judge, of course, but we've added more medical records and sometimes there's more impairments. So during that time period, fair warning to everybody, if you've appealed to the appeals council, do your work, do your treatment work, keep it going, because if you get remanded, you're going to be adding all that stuff to your case. And if you don't do it, you're foolish, because now you're just saying to the judge, flip over your old decision because it was wrong. See? And then he's going to say, no, I'm just going to follow the AC's instructions and not leave out that one little point and deny you anyway. But if you give him all this extra fodder, I don't know that I've ever had one not, but you're giving them all that more, and it's always a case I already know is the person is disabled from every single job out there. That's how I roll, even if they didn't have proof in the beginning. It's that whole workup we talk about, Shanna. If the case stinks now, but you can make it good, so yeah, they do make mistakes. and when they do, they have to go back and follow those rules and regulations, Jen, that we're talking about. And that's what the AC told them. And sometimes the AC screws up and then they go to federal court and then maybe the federal court will say it. So there's all that opportunity. But again, they're human, we don't run on AI. Let's hope we don't, because that would be probably use it for helping, not for decision, ultimate decision. Okay, Virginia on 2/14/25 did a dire need to the appeals council after being denied from ALJ. Now on my SSA.gov, so on our online account, it used to say denied. Since 6/5/25, it doesn't show it anymore. What should I be expecting next? I have no idea. They change up that little, I can't even follow it. Half the time things don't make sense. Half the time they're not accurate. So I really can't speak to it. You should be getting a letter one way or another. If the AC denied you as well, which would be a decline to review your case, then you'll get that. Or they'll say, here's an order of remand. We're sending it back to your judge. Wait, what should I be expecting next for alimony? Which one do they take out of SSD? I don't think they take it out of SSI at all. It would be SSD. If you have arrearages in your alimony or child support, the federal law, it's one of the few things that can garnish Social Security, but not SSI. Because remember, SSI is not Social Security at all. It's supplemental security income. It's a welfare check. So just the Social Security people can be subject to that. SSI is considered the very most minimal amount that someone can, if they're very careful and prudent and pick wisely where they live and what they do, can live on. We can all argue that might not be true, but that's the theory. And therefore they cannot take from that to pay any of your bills, not to mention arrearages and child support or alimony. That has been the law. I assume it still is. I haven't researched it lately, so do your due diligence. Wes Anderson says his case is flagged dire need, yet here we are 10 months in. I suppose it would depend on what the dire need is. I'm sure they have rankings within the dire need categories. If it's dire need because, you're dying, terminal, that would probably be at the front of the line. So all those guys got to come before you. If it's dire need because I'm in a lot of pain, and that probably would not actually count as dire need, only because so is most everybody with a case. So that isn't really so much a dire need. Any thoughts on that, Shanna?
Depends on where he's located. His office may be backlogged a bit, and then it could be what's taking longer. There's a lot of factors that go into that. So processing time.
Yep. And there is a point, I think, where they do go to other offices, like support stuff that takes overloads, but I don't see it that often. Crystal Roberts said, I was just denied at recon on both my initial and recon denial letter. They only had 2 conditions out of many others listed on the letter. They only had 2 conditions out of many others listed on the letter. Okay. IBS and GERD. Usually they put all the ones that you put in your application, I believe. I think it's literally like a form-filled thing. They pull them out. You claimed this. Like how they did those denial letters. You alleged this, and this. So could it be that you didn't put that in your application, Crystal? Sometimes if you do an application by phone with the SSA, they don't record things the way that you say them. And somebody could have left them out because they didn't feel like putting the others in. I don't really recommend phone applications if you can avoid it. I prefer online applications first, which I believe the SSA prefers too, because it saves them labor time, which is a good thing. But it also means that you can put in all the impairments that you are talking about, and no one can take them out. No one can choose that they're not going to go in. And also you can print out, and you should, and they tell you that. And when people don't do it, it drives me insane. Print out your copy, your receipt that says, it's everything you put in there. And then you could see. So I would say it's not common, but I just wonder if you did a phone application or if maybe when you filed, you somehow failed to get those in. That's the only thing I can think of. What do you think, Shanna?
I've had, when we do, the case is denied on initial and you file a reconsideration and you add more medical issues in there. I've actually had a denial on reconsideration before that didn't have half of what I put on there, like any of the new stuff. It had all the same things that the initial had on it. So, I mean,
could be the problem there. Then they're just going off the application and not all the subsequent things.
yeah, because I was like, I thought I put that on there, and I had to go back and look at, like you said, what I had printed, I had sent in before, and I was like, it was on there. So it could have just been a lazy examiner. That happens sometimes. You got people that are working but don't actually want to be there, and you have that at any job. But you just have to add it back all in there. Anything that was missing when you filed the appeal.
Yeah, I agree. Yeah, I will say getting them to, I send letters in every time my person has a new provider. It's just uploaded to the GDS, and I actually uploaded twice. I put it under medical evidence and I put it under representative correspondence because I'm like, they don't tell us which one they're going to use. So I actually uploaded twice. I do see them not paying attention quite a bit, unfortunately. Colette says, I used your videos to assist me in filling out my functional report. Thanks for posting those. You're welcome. Those were probably the smartest thing I ever did. They were one of the first things I did, and I did them for my clients. And then I ended up sharing them much, much later because I'm like, this YouTube thing, interesting. So that's cool. Yeah, the functional report stuff is good. Oops, private conversation. Sorry, guys. I shouldn't say private, but okay. Let's see. Lily says she was at step 3, so she requested a congressional review via email to my U.S. Senator. His office contacted DDS and then did follow-up emails to me about my status. Oh, yeah, that would be typical. I'm just wondering, I know people, and I'm not saying this is you, Lily, some people, as soon as they, they've been at DDS for 1 month, they're like, what's taking so long? I'm contacting my senator. And that's not really a long time. They're working on everybody. Now, on the other hand, if there's 6 months that go by and you don't even have an adjudicator, that's when I think it's time to squeak. And it's been bad for a while. And I just, as a representative, Shanna, I don't know how you feel about this, if you do this at all. I do reach out to the congressperson of my client in certain careful instances, like just because I want him to be put to the front of line in front of all the other claimants for his DDS. No, I'm not doing that. But if it's been 6 months and I can see there's no adjudicator on it, I will ask him to do an inquiry. And then sometimes it might be that the fact that they got the inquiry puts a priority on that person getting an adjudicator. Might be. I don't know. I don't think they're allowed to play favorites. Sometimes I think it's a light, a match under the arse. But I have some videos on this too. Like, congressional inquiries are also not for asking them to put their thumb on the scale. Well, that was my pointer. I mean, my thumb on the scale. To convince them that you're disabled. That's not their role. They won't do it. Just to see if there's a cog in the wheel, a procedural thing, like you're not getting your adjudicator. They'll do that. They'll say, this person says they've been waiting for 6 months. What's going on? And then they'll get a letter back that says, yeah, she's in the pipeline for an adjudicator, in the pool waiting an adjudicator. And I had one letter back that said, we have flagged this as being congressionally inquired. And then the other one is just like, it's waiting. Like, that's what they told the congressperson. And that person is still waiting. And I think it's been a really long time. And I think he's a veteran. So you want to talk about, it's not that it's a dire need. It's one of those more expedited, the 100% P&T veterans are supposed to be given more priority in terms of being in line. But in this particular instance, I'm not really seeing it. Spine surgery journey. Wow. Hugs to you there, fella. Hey, great show. I'm 55. Oh, you're a youngster compared to me. I have 40 years in work credits, 34 years on my job. Question is, will be applied the grid rules to my case? Of course, they will check to see if you fit a grid rule. Absolutely. Once you're 50, that's mandatory. And you're at 55, which is even better than the one at 54. 50 to 54. So yeah, they should. So figure out all the things that you need to prove, because it doesn't mean you win because you're under a grid rule. You just have a certain set of rules that you have to meet, as opposed to a much broader set of rules. So you have it easier in that respect. Thoughts on that, Shanna?
with his being over 55, the main goal is for that age group is to prove that they can't do their past work that they've done. So if there's something, medical issues that count him out from being able to do that anymore, then that should fit him into that disabled group under the grid rules.
And they have to prove they can't do medium level too. They have to be light or sedentary. Spine surgery continues. I've seen the Social Security doctor and they are in the process of checking on my work history. My question is if I didn't pass one of the 5 stages or they keep going. Well, you're in you were in step 3. They're probably at step 4/step 5 now, which is when they're going to apply all those, all those rules, right? They had your medical records. They sent you to their own doctor. They're probably pretty much done with the medical. And so I would think, I usually say after the consultative exam, it's usually the end of the long process. And then barring people going on vacation or quitting, usually goes to the adjudicator, gives all the medical records to the medical expert who gets an RFC for you, which you need that RFC to figure out if you fit a grid, and then sends it back to the adjudicator who then matches up all those little laws and says, checkbox, 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 grid out. That's my visual. Okay. Lily says, correction, it's requesting congressional inquiry, not review. Yeah, we knew what you meant. No worries. RD, nice to see you again. Hello, looking at my urologist notes, she put chronic. I need another surgery to remove mesh. Oh yeah, that blows. I think we talked about that, right? Does the word chronic help my case? I believe so. Chronic means sometimes when it's acute, it's short term. Chronic definitely means it's not short term. So, acute can be good for severity. So if you have many acutes, but if it's the acute and then it's gone and then it's acute, sometimes there's a chronic with acutes, like it's almost like a chronic at this level and then acute bumps of severity with the same condition. So, but I think chronic is good because if it was just a snapshot problem, then it wouldn't meet the 12-month duration. So what do you think? Am I looking at it a weird way?
No, I don't think so.
Let's see. Wes doesn't think they automatically apply the grid rules. If they would have on my initial, I think he's probably going to say I would have won. Actually, what I'd probably suggest is that you need to know those 3 rules that you need to have met and figure out which one you didn't. And you can get that information if you know how to read it on the DDE, the Disability Determination Explanation. You're going to find out what RFC they gave you and the answer of whether you could do your past job and the answer whether there's transferable skills. That's where that's at. Because once they figure those things out, the grid rule it's automatic. It's not like you have to argue that it should be applied. The law says it applies.
And he needs to make sure that they've got all of his medical records because that may have been the issue.
Yeah, which means you didn't do your job. No offense, Wes, but you have to be on top of your own case. You are the one that's primarily, if you're not represented, responsible for getting the evidence of the SSA. They have a responsibility to help. But if they ask for the records and your doctors didn't do it and didn't provide it, whether for whatever reason, maybe they lost the request, maybe the mail didn't get to them, they're not going to keep asking forever. And the case is over. But if you stay in there and stay involved and make sure, speak to your adjudicator, find out what, if anything, they haven't gotten that's on your list. And of course, you've been telling your adjudicator every time you have a new doctor visit, right? You have to do that because if you don't, they're not going to have the stuff that you say shows that your RFC is low enough.
Yeah.
Maeve says, I've worked with people with severe disability. We hear you. One man was in an electric wheelchair and had limited manual and physical motion, but he was a programmer. I think that's what you're saying, right? Will depend on job, manager, and company if it is so apparent. I'm not sure what's depending on it, like whether they'd hire somebody, I suppose. Yeah, like a job like that, they don't care if you're in a wheelchair, if you can do the work. And that's how most jobs are. They don't really care what your issues are. Can you do the work with or without accommodation? They just want the job done. Okay, Sunflower says, hi, Sunflower. Have you helped any clients be successful in getting their benefits for severe interstitial cystitis? I have had those cases. I have one now. It's funny. It's never the only impairment, ironically. You as well, Shanna?
Yeah, that's what I was going to say. Usually when they have something like that, they've got other issues, most often related to autoimmune issues and that need to be addressed as well. So it's rare for a person to get approved for just one medical problem, because most of the time you've got once you get one, you've got half a dozen more that come right along with it.
Right. And it's those others that sometimes make you go from you're 95% there.
Yeah.
They fill in the other 5% you need to.
No matter how little you think it is, get it treated, get it documented that you have the problems, because each little problem counts you out of another thing that you can do work-wise.
Yep. And Shanna, you and I feel the same way on that. And I hear other representatives, attorney and non-attorney, certainly attorneys, I've heard it say, focus on the big ones. And it's not a matter of focus. You're always going to be focusing on your big ones because your body needs it. But do not put sufficient focus on the small ones, because that's how you get a denial you don't expect.
Yeah, all things, no matter how small.
Mm-hmm. Hi, Jen. Jen says, it wasn't a mistake. You have my letter. Jen must have sent me a letter. Yeah, Jen, as you know, with my time frames, I can't necessarily read things people send me more than when I did, right? You could see what she said if you wanted. This judge has a reputation in this county. Many lawyers know she's a particular problem, intentional negligence. Okay, well, I'll take your word for it. But that's what the appeal's for. You know what I'm saying? Like, that is what the appeal's for. I will tell you, I hear it all the time. And I'm not saying it's not true in your case, Jen, for sure. I mean, you're very smart. You know how to read their stuff. You picked out stuff. But I will tell you that everybody says that. So that's why you have to take it up to appeal, right? And you are, right? Because most everyone who loses says the same thing. They do. Because they don't understand. And you do, Jen, but they don't. So that's where the appeal comes in. And by the way, I think we've talked about this before, can there be a mentally unstable, ill-minded, mean ALJ? Of course. Any profession, you can have some psycho up there, right? I mean, it's just a fact. Would it be exceedingly rare? Of course. But I believe it can be so. Again, that's what you will be appealing on the actual things that are in there, of course, not the opinion of what creeps they are, right? But that's what the appeal is for. And you show it, and then you'll see. If the goods are there, you will come out okay. La Lulu. Wow, how generous. Oh, Shub. Yeah, Shub. So yeah, Wes was saying how he wouldn't be in reconsideration right now. I told him in my appeal documents to use the grid rules due to age 59. Like I said, they already know about the grid rules. In fact, they're the ones that designed them. So phone interview January 6th. And Williams is talking about his, he had filed January 6th. And he prevailed May 8th. That's awesome. Yeah, our interstitial cystitis is horrible. I don't have it. I would think anyone who's ever had a UTI that's painful has had a sliver of the experience that someone with IC has. That's my perception from the descriptions of pain and the duration and the bathroom time by people who have had it that have been my clients. So I feel for you. Very much. It's a nightmare. Wes says, why does my benefit verification letter dated October 2024 say I'm entitled to monthly benefits, yet I'm at step 3? Maybe that was the estimate. Maybe you got to just take a better read. I don't know. I don't know. I haven't seen it, so I don't know what you're looking at. Is it a estimate of what your benefits would be? Perhaps? I don't know. Can't say it without seeing it. Lily brings up Chat GPT. It's so funny. I was just looking at Chat GPT this week, very curious about it. I'm an old dog, so it's hard for me to use. A congressional inquiry, it says, and I think this is, I just read it, it sounds appropriate. A congressional inquiry for Social Security disability claim is a way to have your elected representative or senator step in and help facilitate communication with the SSA. Yep, light the match. That's what I always say. Light the match under the butt of the SSA that has been ignoring you, or there seems to be a cog in the wheel and something's stuck. And they need communication to be alerted to pull it out and get it back on the track again. It's kind of how I look at it. What do you think, Shanna?
Agree, yeah. They help a little bit.
Adam, you're welcome. I'm glad for you, Adam. Okay, so Crystal. Okay. Crystal's saying that she did list all of her conditions on her recon application. Is it your recon denial that they didn't include them? Yeah, that would be troublesome. So, list them all again when you do your, I think you're saying you got a denial on recon then, Crystal, was it? Or did you get only a denial on initial and you're saying it didn't list it, and now I listed it on my recon, which will be good. And then you, of course, will have your doctors that are treating you for all those additional things. And if you're going to ALJ, you're going to relist everything for the ALJ. Kosherish says, if approved based on a laundry list of issues, yet not told why I was step 3 approval. How do I determine what to worry most about for CDR? Step 3 approval would be you met a listing, correct? Because they didn't have to go to step 4 after getting an RFC. Am I doing the tree right, Shanna?
I believe so, but for the CDR, you'd still just continue treatment for everything.
That's right. Yeah, just keep doing it. And I think everyone should get their file after they win. I do. I would do that request to the SSA, and I would get it, and I would keep a few copies digital. You don't want a paper copy, that's going to clutter your home. But keep a few safe, secure copies, in the cloud on one or two of these little thumb drives somewhere in the cloud. So you do have it. And because things do disappear, with the SSA years later. Crystal clarifies, thank you, Crystal, that she did do it online and had all of her conditions listed. Then that's weird. So I don't know what happened. That just seems, do they then retype them? I don't know. One thing I do know, on the transmittal, which is not something that I really care about, but it's created when they do a determination. It's not the DDE, it's that one pager, Shanna. It just has all these little fields filled in. I know they only have primary condition and secondary condition. It's like two broad areas. So that's annoying, but I guess they just need to kind of narrow it down.
She just needs to relist them in the next appeal.
Yep. Just do what you got to do. It's inexplicable then what you're talking about. It's offensive that they did that. Kosherish. Oh, Kosherish is 50 to 55 years old. No. Well, you might be, but it depends. Are you 50, 51, 52, 53, 54, or 55? Because anything but 55 is going to have a different set of rule under the medical vocational rules, which is also known as the grids, whereas 55 will be different. But anyway, same thing stands. You probably met a listing, so that's really good, and you can find out by ordering that file and get it anyway. Kosher, keep it with you, because that'll be your comparison point when they do a CDR. They will be looking at that and those medicals to determine if they see improvement in your newer medicals or whatever your presentation is now. Fibbity Jibets, you look like you're going to figure out. Thank you for the filter technology, because believe you me, I am very haggard in person. Yeah, for sure. Virginia Gomez, just a question. As a disability lawyer, why would a Social Security lawyer fight for a denial on my ALJ? I'm 52 in California with a lot of problems. Why would a Social Security lawyer fight for a denial? Are you saying someone tried to get you denied? That probably didn't happen, Virginia. What are you talking about?
I think maybe they mean like.
Is she joking?
Maybe it's file an appeals council appeal. Like if they got denied by the judge, and why would anyone appeal it for them like that?
Well, an appeals council appeal takes 3 seconds, because they're probably not going to do if they weren't the lawyer underneath, they're not going to know the case. So they're not going to be able to describe how the ALJ did mistakes, because they don't know the case. But they can file the AC appeal. It takes 3 minutes online. You don't have to do a brief. And the appeals council, my understanding, is generally supposed to review the entire thing anyway. It's not only reviewing something that you told them to review. So I've taken cases. Yeah, I've taken cases that are going to the person who wants to appeal the AC. I don't mind doing it. And then if they get it remanded, we go back to ALJ. And during that time of wait with appeals council, I make sure I get all their stuff and take it from there. Obviously, I've well vetted them and their situation. It's like an intake I would take, at an inception. Like I already know I think they're disabled. They just had difficulty proving it. I don't necessarily know that they're going to win at appeals council, in which case, probably what I would also be looking at is, would we be filing anew, and can we, if AC declines, they could also appeal to federal district court, and I would give them a few names to go look at to do that while we filed anew. Your thoughts, Shanna?
Yeah, if someone comes in with a judge denial, I'll look at it to see, what, if anything, that I can see that the judge may have been wrong about. I actually did take 2 last year that were remanded. One of them was crazy. The judge had her RFC set to where she had no interaction with the public. But one of the jobs they listed that she could do was daycare worker. And I'm like, just because they're little people don't mean they're not people. Like that.
And how about the parents? How about those parents?
Those are 10 times worse as dealing with a child's parent. So that one did get remanded, but the other one did too. But the other one was on a technicality. But sometimes if the letter, depending on their medical history and their medical issues and their treatment, sometimes I'll just suggest that they just, do X, Y, and Z to get it, strengthen their case and refile versus wasting a year and a half waiting for appeals counsel to deny just to do the same.
That's right. That's right. I just had a situation. The person might be here actually right now, where it wasn't with me, but decided to not file an appeals counsel for appeals counsel review. That was the thing about getting an appeals counsel review dismissed that was inadvertently filed. And I guess it is possible to get it canceled. Probably more possible as early on as possible, as soon as the mistake is made. And that was the decision. One does that when they feel that, all right, I didn't realize maybe it's the kind of thing where I should have been treating for that bad hip, that I was focusing on my migraines. Yeah. You know what I mean? Alone. And so, you'd be spinning your wheels, wasting time and burning up your time by doing the appeals counsel when you're never going to win. And instead start afresh, make it strong, and get her done.
Yeah.
Dimples asks, is it a red flag if I suddenly have 3 new doctor reports in the last few months and then apply at the end of October? Plan is to try to hold off applying, as you know. I don't think that's a red flag. Red flag, no. I don't think that's the case. Because if you're having problems, you're going to be going to doctors. Sometimes it might be better to have those doctor reports if you're working right after you stop working, so that you can show something has gotten worse and you're not working versus you had that and were still able to work. I've seen that kind of made as a baseline, like, well, the person could work with all this stuff. Nothing's changed now that they're not working. So if they could work before, so sometimes it takes a little bit of analysis maybe to see if, that's assuming you're working right up until you apply. And then you just stop working and then you apply. You oftentimes lose that. And I think we talked about this. That initial is kind of lost because there's nothing new. And the exception is, of course, if it's really, really robust treatment and it's like bang, and it's clear that the person had to stop, had to stop. It was becoming cliffhanging, and because the evidence before stopping is so robust. I don't know. What do you think about that, Shanna?
The more records documentation, the better.
Do you have any opinion on filing the filing like right after you stop working versus waiting a little bit, showing that you're going to these doctors and getting a little more robust stuff so they have something that's...
I like for mine to, obviously, in the perfect world, because most of the time that's not how, we don't get them like that. If someone knows that they're having a hard time and considering needing to quit because their medical issues are getting real bad, I would like to get them before they quit so we can build up the medical records and build up the treatment to show the progression of it and things like that. But, you just got to make sure you're getting treated for everything. And when it's time, when you can't do it anymore, the only thing it's going to affect is how much your back pay. Because if you've worked and paid in and get SSDI, unless you also qualify for SSI, you don't get them first 5 months anyway. So you can file that first day, or you can file 6 months later. It's not going to affect,
See, I find it differently, and I don't know, maybe it's for different areas. I have found that over the years that it's not unusual. It's not always, but it's not unusual, particularly if there's something acute, this wouldn't apply. If I've found that a lot of times and I think because I saw reference to it is where I made that kind of connection years ago. But it was like the person is able to do that sedentary job, say, and then suddenly they quit. And they've been going, for treatment for years, and they've nonetheless been able to do that sedentary job. Nothing vastly changed in their medical records. They've been steadily going to the doctor, complaining of pain, being treated, and then they just quit out of the blue, meaning they didn't get hit by a truck or something. No vastly different medical records, and I've seen a lot where it seems like their initial is now like, number one, they'll say, it was almost like they were saying they're not disabled from this condition. They were working with the same condition all along and nothing has gotten worse.
Yeah.
You know what I mean? And so then they deny them on initial. And then of course, recon, just being that it's the same office reviewing it, blah, blah, blah. So there's not, perception partially true that it's just going to be a rubber stamp. But I think less so if they start to work up on it, then that they lose the bite of the apple. Because they file right away. SSA is looking at the stuff, say within 3 months of them stopping, and they're saying, why'd they stop? That wasn't disabling. That stuff is not disabling. Look, they showed it's not disabling for all this time and nothing's gotten worse. So we think they can do their past relevant work because and then particularly if it's sedentary, I'd say sedentary or light. And then I would say specifically those, and they deny now had the person, and now they got a recon, which again, chances of prevailing on that are less than maybe what would have been if they didn't file coming out the door of retirement or whatever you want to call it, stopping work, and they treated and complained and treated and talked about how they couldn't work anymore and they stopped, and that's now all on the record. By the time, let's say you file it 3 or 4, now they have all this stuff showing after the description of why they quit. It was getting so bad, I feel like I need to treat more, to help my body, which I couldn't do when I was like all these things. And then I just think it's a greater chance of winning on initial. That's just my perception. Like if they don't file coming out the door.
Yeah, I agree with that.
And then there's different cases. Like you'll have one that I would say this is not true if it could be true if they just went for surgery, right? Because so many times they'll say, well, the 12-month durational, the surgery we expect you to improve, therefore you don't meet the 12-month durational because we think you're going to be able to do some sort of work within 12 months of that date you stopped. Now, had they filed that month, maybe 6 months later after the PT is all over, post-surgery, and they're still screwed up, now you have that evidence that the surgery, is not putting them back on their feet really quick. Yeah. I don't know. All right. The things I always babble about to my people. So I thought I'd get your take on it. Spine surgery says, I've been disqualified from my job through a QME. So all these, okay. So he has these pending surgery, right? Well, this helped me at step 5. I would think step 4, perhaps, if you got your job told you can no longer do your job because you don't meet something. And this happens with like commercial truck drivers. It could happen, like they have to meet certain physicals. And if they don't, they get it revoked or whatever. Obviously, people like airline pilots, things like that. I'm guessing those guys have to do it. I don't see a lot of pilots, although I did have one recently. So I think that could help show that they can't do the prior job. So that would be they'd pass step 4 and then they just have to get through, but can you do any other job? Does that sound right?
Yeah, I had one last year he was a truck driver and he couldn't pass his CDL because he had drop foot and, therefore he graded out. Yeah.
Yeah. So when she's saying graded out, guys, remember, so let's say you're 55 with a QME, you can't do your prior job. That's one of the 3 prongs: prior job, no transferable skills, and your RFC determined in step 3 says you can do no more than light work. So you can either do sedentary or light is fine. You're still disabled, but you can't do medium. That's what you have to prove. Right. Medium would be like over 50 pounds. Or 20 to 50. And then above that would be heavy. Yeah. So the QME helped take out that one prong, right? Can't do your prior work. You still technically have the other 2 prongs. Obviously, your client met those other 2 prongs too, right? All right. So Wes says, filed my initial myself, an attorney filed my appeal. I hadn't found you yet. Getting in touch with my current is difficult. Maybe I need new representation. I wish I would have found you first. I hear that a lot, Wes, the lack of communication. And it's the easiest thing to do with the portal, I'm telling you. I'm always telling Shanna about the portal, right, Shanna?
I can't wait till I can get it.
Yeah. Soon. If I see a new specialist just prior to applying, this is Dimple. If I see a new specialist just prior to applying, my insurance company just denied my knee replacement because they think I just decided to see the ortho. I appealed, but we shall see. From a medical business perspective, it seems like, yeah, they're not going to do, they're going to make you jump through all sorts of tests and hoops and maybe PT before they're going to approve a recommended surgery, I think. Yeah. My big thing is being really strategic about when you stop working, which can be hard because people are like, but I need the money, right? And I always say, consider going down at least below SGA part-time. A, that frees you up more time for treatment. B, you could still use that date you drop down, even though you're still making money. That's going to be your alleged onset. But then it buys you time to not file the second you drop down when you don't have all this post-work evidence of things that are now different than when you were still working. Brian's vlog. Ooh, I wonder what you vlog about, Brian. Is it primarily mental health claim for SSDI more likely to be approved with medical issues as well? Well, I would say yes, but it all depends on the vocational profile, which mostly means your age as the biggest factor. What do you think? It's kind of
the way that I work them, and similar to you, regardless of what your main issue is, get all the problems treated and documented and claimed, because all the problems are going to be why you can't work, not just one thing. So even if the main thing is mental health, you've got backaches or stomach problems or breathing issues or whatever, that can count out a job somehow down the line.
Yeah, and particularly, if you're under 50, Brian, to get this D based on mental alone, even if you have physical, but if it's going to be based on, you have to be so severely mentally dysfunctional, unfunctional. It's so extreme. It's like basically, even if you're not hospitalized, you're always on the verge of. I mean, that's how significant it can be, or that you should be to stabilize. I'm speaking generally, but that's how arduous it is for pure mental health, and particularly under 50. When we're over 50, it's a little different because you'd have to, first of all, for the grids to apply, there must be physical impairments. They don't apply to a mental case over 50. They only apply if there's physical. So in that sense, if you're over 50, if you're 50 or older, Brian, you have to have those medical issues, meaning the physical. Okay, we got about 20 more minutes, guys, and I'm going to try to be timely getting out of here. How you doing, Shanna? You holding up?
Doing good.
Okay. Heidi. Ooh, Heidi's back. Nice to see you, Heidi. DDS closed file on May 9th, sent for federal review, passed federal review, and sent to local office on May 24th for non-medical review. Is this a good, bad, or not a sign at all? My personal opinion is it's a good sign. If you, hold on. No, I should say I'm not sure. I take that back. You haven't heard. Yeah. I don't know. What do you think, Shanna?
I mean, that's one of those things that really doesn't mean anything, and they still have to do it regardless of a denial or an approval, unless they call you flat out and tell you, and it says that.
Yeah. The only reason I was going to lean towards good is because of the traditional view that if it gets sent up for federal quality review, by and large, the impression has been that that's because the adjudicator awarded you. And usually when that happens, the federal review finds that the adjudicator did fine. And then it goes for, like any other adjudicator award, goes for non-medical review. But of course, adjudicators that deny, as we've all learned, they still send you for non-medical review, or so they say. I personally don't think they are. I think it's a mistaken message. I mean, it would seem to me that only awarded cases need non-medical review. Why would you non-medically review a case that is denied on medical? It makes zero sense, and never was the case. So that's like a thing from about 2 years ago now, and it's ridiculous. So Heidi, going back to it, Federal review could be a good sign, but we're not sure because technically I think they're supposed to review, in theory, denied cases as well to make sure the adjudicator did that right too. Shoot, you give a hug to your wife for me. That's your better half. Too funny. Tell her to join. Tell her to say hello. But yeah, good spouses are all our better halves, I would say. I've got one of those. A good partner in life is the best thing next to sliced bread. Sunflower says, what happens if your mental health provider doesn't send the records for your treatments? Yeah, records requested but not sent. It's the only thing missing. Would you like to start that one, Shanna?
All you can do is try to get them yourself and send them in. Sometimes it depends on what facility. Sometimes they'll let you have them. Sometimes they won't. Sometimes they'll reduce them because you're asking for them, depending on what's in them. So all you can do is try. Or call your examiner and tell them to try again. Yeah.
All of the above, I agree. Also, what I tell my clients, I'm like, we're going to shoot them over a letter saying they have to follow do the SSA, comply with the SSA request. I said, but you want to call your doctor's office and say, listen, you've gotten a request for medical records. I need you to comply with that. It's a HIPAA requirement. They have to. And I want to just throw out here again, we haven't talked about this in a long time, but if your medical provider does not comply with a HIPAA request, whether it's from the SSA that you signed, so it's your signed request for the SSA to then ask for your records, or like in our situation, I have a form HIPAA. It's the high-tech HIPAA compliant one that's patient to patient. So technically it's coming, the patient is asking for the records to go to the patient at a particular location. If they don't comply with that, and they got 30 days, just 30 days, it is a HIPAA violation. It's a violation of the access provisions of HIPAA. And you can, in about 3 minutes flat, file a online, and it also can go by email, I think, or fax. But it's through the Office of Civil Rights. I've done them, helped people with them. And they're not going to enforce it on your specific behalf. But if they get enough complaints about a particular provider, those providers sometimes get whacked. Hundreds of thousands of dollars for continued violations. I wish the HIPAA access and the Office of Civil Rights that enforces it had more bite to their bark. It's like they're little chihuahuas, but it's the one thing you have. And then I would probably, I don't think I've done this on behalf of I do the logistics. It's not, my name's not on anything because that would defeat the purpose. But I would send a copy of that HIPAA complaint that you went to OCR to your doctor's office and say, just so you know, you're going to be hearing from them. Because one thing I have heard, and I don't know if this is true, I'd love to get someone in here who's an OCR person, works through them or with them. I believe when they get a complaint that you have provided the substantiation for that, yes, you made the request, and yes, it's been over 30 days, and that they send a letter to the provider saying, this is the office. I would think any provider is going to poop their pants with by the way, we're seeing all those little floaty things behind my head, right? I think it's because the sun is getting dark. It's weird. Something about the lighting, but they send them a letter, and I have a feeling a lot of them get on board as soon as they get that letter. They're like, oh crap, because they know that it can be sanctioned. I have a couple of articles on major sanctions. Sometimes it was for privacy violations, but I think there's one or two about overcharging and or just failing to provide, period. So I say, stick it to them. I do. It's so wrong. They're controlling your future financial life. Potentially even your retirement benefit amount. It's ludicrous.
Start making calls and throwing a fit. Somebody will do something.
You got to you have the right to file that OCR complaint. And it's so easy, guys. It is so easy. Reach out to me if you feel like you can't find the link or something. Jen says, thank you very much for acknowledging that. Yes, there can be bad ALJs that, in fact, do not follow the rules. Federal judge basically found. But people die while yes, this is true. All true. RD. I'm also having rotator cuff surgery. Pelvic and bladder pain is a nightmare. I can't even. Yeah. RD, I think you and I have talked about this. I feel for you. Now, of course, you're including your rotator cuff surgery in your case, right? For sure. You are limited in reaching and all these other things with that. Lifting. Okay. Dimple's talking about how her work productivity is declining and my off task has been increasing. Consider going part-time under SGA. Dimple. Some days I feel like I've been hit by a truck. Yeah. Beth Prince is asking you something there, Shannon. I don't know if you see it.
Yeah, I see that. Usually no public interaction is related to mental health issues. Like, that's one of my goals, is to get the checkbox for that, because it limits the jobs you can do. Because any other time you can do, like, light duty is like a cashier, and they'll throw just about everybody into that category. But unless they can't interact with the public, then obviously they can't do a cashier job. So, mental health issues help contribute to that and decrease in job opportunities.
Yeah. There's situations sometimes where this is going to sound unusual, but I'm thinking now that Beth, you brought it up, public interaction, there are some conditions that cause very offensive to an otherwise hygienic person who's doing their best and literally showering all the time, incredibly strong odor. Like, they can't escape it. I agree with you. It's generally something we consider with mental health. But as I was going like this while you were saying it, and then I thought, wait a minute, there could be an exception, and that would be something like that, maybe. I'm throwing that argument, like, the person isn't going to take public transportation, for instance, but working with the public, and that might even be you can't work with coworkers because it would be very distracting to them. And it's funny because that's in the list of descriptions for mental health stations. But I don't know why that wouldn't also apply to something like that. And I'll tell you, tangentially, when I was in my 20s and I was working at this big, I think it was a pharmaceutical. It was a temporary position in human resources. It was like a side job while I was building my business initially. And there was a person. I went into the bathroom one morning. I was one of the first people always there because I had a long drive. And I'd go into this big fancy marble bathroom with 10 stalls. And on occasion, it would smell so rancid. So rancid. You know, the cleaning people were there. This is a big corporate, beautiful place. So, like, you could barely go in there. It was so bad in this big room that was marble. It was really strange. And I remember asking my supervisor, who we had a really good relationship. And I said, it stinks sometimes when you go in there. I get here in the morning and I've been driving a long time, so I always have to go to the bathroom. And she said there was a employee who had a condition, like a medical condition, that it just emanates from her. And I don't know if it was, gyno-urinary, or if it was the poor. I don't know what it was at all. We didn't go into it, but I was like, oh my goodness, like, how disruptive of life. And God bless the person, had a decent job at a big company, but it was incredible. So I know these things exist. That's the only time I've ever seen it myself. But I don't know if that's like all day long for that person that I'm referring to, or if it was just in the morning, just going to the bathroom, because I don't know how anyone sitting next to her, it wasn't in my side, obviously, would have been able to work. So that would eliminate all public jobs, all coworker jobs. Now, I do think there are jobs where you don't interact with coworkers either.
Yeah.
Probably not a lot, but there are. What would that be like? Laundry room, hotel laundry room or something?
Yeah, there are light duty jobs that they can fix it to where you can.
Very solo. You're very solo.
Table worker is one I've been getting a lot lately. So,
but that table worker,
you're working by yourself. Yeah, like an industry. Yeah.
There's no one else in the room. They give you one big
in the room, but you're not working together.
So, like, what would that be? Is that arguable?
I'm working on it. It's like it's like a factory type job where they'll sit at tables and like sort products or whatever into a thing, but you're working solo. But
they're saying you're like 8 feet apart, therefore it's kosher. Okay, so I guess it depends on how far
your job isn't. Does it depend on what another employee does, and you don't have to actually interact with each other and that kind of thing. So yeah,
right.
I'm getting that a lot here lately. But if you've got any arguments, I'm open to all ears.
Yeah, and you're talking about a mental health case. Is that a mental health case?
They have both issues, but kind of just that was one of the things that knocked them out of
Yeah. I don't know. What about being distracted by others and all that stuff? I don't know if there's a symptom showing up that would show that they get off task or, like get distracted by things out the window or what that person's doing over there,
Yeah, that's another that they use, that whether the person can stay on task regardless of how many times they need to sit or stand, that kind of thing. I've had that come up recently where they were like, regardless of sitting for 2 hours and standing or whatever, you could still remain on task the whole time. It's like, who can?
Yeah. RD gives some details. He says, he or she, 56-year-old hairdresser of 38 years. I think I might grade out at 2026. Yeah, whichever number, but yeah, maybe, just make sure that you can show that you can't do medium level work, which is lifting that, over 20 pounds. What is it? Occasionally, which is up to a third of a day. You might need to show symptoms of not being able to be on your feet that much. You have the shoulder thing, which kind of prevents possibly doing the job, right? RD, I mean, you have to use your hands in front of you to do a lot of things. I've done a lot of hairdressers. I hate to say it, but you folks really get disabled. I don't know whether it's those chemicals or being on your feet so much. It's bad. Neck. I see a lot of neck and hands, but I always wonder about the chemicals too.
Yeah, it causes a breathing problem. So if you have any issues with your breathing whatsoever, get it checked. Yeah.
And then think about like where all that stuff, when you breathe it in, where is it going? Into your tissues, connective tissue? I don't know. Yeah, I mean, obviously they're going to look at that. So really focus too on the fact that you can't be on your feet 6 out of 8 hours. I think so that will pop you out of light. You don't have to get popped out of light, but by popping you out of light, you're going to be popped out of medium, because medium is on your feet like light is. It's just heavier lifting. And that should, if you can get the evidence that kind of really points to that stuff, I think you've got a really good chance. RD, I stopped working after 4 surgeries. I try to keep going. Yeah, and you know something? If you go to a judge, that judge is going to see that you kept going back to work, going back to work, going back to work, and trying everything you could. And while that's not required to win, I think it's an optic that most judges would appreciate, the work ethic. You remember John Gongon, right? He was here you were here last time.
Yeah, I think
he's our friend. Okay. He's always funny. He's always good to give you a chuckle. Okay, so Virginia's saying that with lupus, sciatica, L4 and 5 problems, that's lumbar arthritis, hypertension, fibromyalgia, I think you're saying, severe carpal tunnel, pre-diabetic, and still they denied me at ALJ. Any reason for it? Just a question. Virginia, you may have mentioned this in a prior post today or another day, but how old are you? I mean, you've got a lot of severe stuff. It sounds to me like they might have said you could do sedentary. And if you're under 50, if you can do sedentary, you're not disabled from all jobs. What are your thoughts there, Shanna?
Yeah. She says she was 52.
Oh, she does? Okay.
Yeah, it was in a prior. And it just comes down to probably not having enough documentation.
The evidence of this stuff, and
just having a diagnosis alone is not enough.
Yeah, because I mean, severe carpal, again, it's going to be the medical evidence about it. So if the medical evidence showed, say, severe carpal tunnel, okay, that's going to probably way using your hands. They go very, very hardly lenient on this. They're very liberal in saying someone can still do frequent, just not constant. I don't like it. When we know that it should be a far more conservative. No, you can't do frequent. It's going to be something less. Lupus, sciatica. How often does that flare? All those things. If they found you could do 52, they probably found you could do sedentary then, right?
Yeah, that's what I figured. There's a lot like within that sedentary range lately.
Well, no, they must have found that she could do light. Forgive me, right? At 52, because if she could prove that she was limited to sedentary and can't do your prior work, Virginia. So if your prior work was sedentary and skilled, that's might be the problem, because they're saying you could still do sedentary. And if there's no reason why you can't do your skilled work, transfer those skills, then the grid would not fit you. But that's an evidence thing. So if I forget where you're at now, if you are reapplying,
ALJ, I believe it was
denied. So are you appealing? Did you appeal? Where are you at? Are you filing again? Get a representative if you didn't have one, so you can get that evidence advice that you need and how to, where to be directing those efforts. Talu, which I don't know if I'm saying it right, but I think we met last week, right? On the initial application, they ask when you stopped working. Is this the date we became unable to earn SGA, or only if we aren't working at all? I'm still working, although very part-time. Mine's different on this one. I don't know how you handle that. There's a few different questions in the application that tend to touch on the work stoppage. I'm starting to get all right, I'm putting when they stopped SGA. And then I will put someplace else, wherever it is, that day, maybe even in remarks, I forget. But the day that you became unable to work, I'm going to assume they mean work SGA. I'm assuming that means work SGA. So I put that in, and then in remarks, I will make sure it's clear that you're still working part-time, because then they're going to want SSA 820 if you are self-employed, or an SSA 821 if you're working part-time for an employer. And we'll get those together at the same time. It won't necessarily go, it's not going to go in with your application, but we'll have it all ready to go, because that's what's going to be coming down the pike once they find out that you're still working. And you got to be clear that your activity, you're working part-time, but you're not working SGA. So that way you're covering your bases. If they really want it the other way, they don't explain, but they say unable to work. But we know the definition of able and unable has to do with SGA. So that's why I run with the SGA threshold. What do you do, Shanna?
I had never thought of it that way, so I might have to reevaluate.
Well, it's weird, right? It's definitely ambiguous. So I don't think any way is right or wrong. I do it this way too, because it ultimately ends up being very clear, I think. Because I played around with it for years too. I was like, oh my God, look, these questions are not, and nobody really on this side of the fence knows. So it seems to work. I just did one where the person, well, it's funny. You have your day stop working, the year. Say it's 2019. 2020, they get a settlement check from the employer for some sort of dispute. So that's a year later. So that looks like they're still working in 2020, getting an SGA check when they weren't. So we had to make all that clear. But they also started working part-time self-employed. Well, no, first they worked for a governmental agency per diem, shall we say, for 3 months, and it was per diem. So it was like maybe $1,000 or something over 3 months. So that was employment, not SGA, and then they had self-employment from that same year they stopped working the full-time job. They also had this, they were trying to do a self-employment part-time thing with the skills they had, because they couldn't do full-time anymore. So we literally this weekend, I did, we put together an 820 and an 821, because the application went in, a week or two ago, and they're asking for those, which I kind of anticipated, because we explained, I put it in the remarks, like, this is the day she stopped working. Nothing was, and they asked the question, have you had any money greater than what or whatever after, all that stuff. No. It turns out the part-time work ends up being in the red anyway because of expenses. It never ended up being viable. But explaining in their marks, because they're going to potentially see something anyway, and you want to get ahead of it, is the way I look at it. And I always tell people, I'm like, it's going to be, you just want to get ahead of it and be prepared. So we did the 820 and 821, and they were sent in, what's today? Wednesday? I think Tuesday, yesterday. But worked on them over the weekend, because you have to attach all your tax returns when it's self-employed and all that business. For the 821 employee, we just shouldn't have pay stubs. The W-2s from that post alleged onset date of her date of full-time work stoppage. Those are after that is every W-2 she had, which I think there was only one. Well, there was the one from her employer where they gave her a settlement. So I sent that in to show, see, it says retirement. It's not wages, even though they tax it like wages. And then the 8-1 had to have all her tax returns, all her Schedule Cs, and all her 1099s. So she set me up the whole boatload for each year, and I just pulled things out and put them together. And so from 19 to 24, there was like 40 pages of stuff attached to the 821. Real pain in the rear, but it's got to be done.
Yeah.
Got him in. So to be more concise, now that we've just babbled about it, Talu, I would put the day, this is what I would do. The day you stopped working SGA is the day I would say I became unable to work. And then I would say in the remarks, since the date of so-and-so, at most, I've only been able to do part-time non-SGA work. And then it's going to, then they're going to ask you for that if you're working for an employer, the 821. Daryl, I had my physical exam. The doctor was surprised of all of my medical records. She said I had a good case for full disability. It's a good thing. You can't say for sure, but I always think it's good if the CE is saying, I think you have a good case for full disability, because they know what the rules are. What do you think?
Yeah, like we had a question similar to that earlier. As long as your medical records also support what that doctor is saying, then you should be good. Because I've seen some that have a good report, but they don't have enough medical records to support their findings. Most of the time the CE is going off of what you tell them and versus medical records and that kind of stuff.
And I think what Daryl's saying is that the doctor actually said it to him in the appointment, like, just like, what do you think? The fact that she said that, I mean, it's better than her saying,
it means the report.
You're looking pretty good there, son. Why don't you have a job? If she says that, her opinion is not very good.
It's always helpful when they are like that.
Yeah.
It means the report's going to be good and in your favor to.
Right. And then like what you were saying, Shanna, and so long as your medicals are kind of supportive of that too, and that could be okay. Where were we with Wes? I know he's 59, been heavy construction, truck and all my life. Cannot do any safety sensitive work, medically unqualified. I'm so frustrated. All right. Your memory is better than mine, Shanna. He got denied. He said it was on initial. We've talked a lot with Wes today. I'm just scrolling up.
Yeah,
okay.
Initially himself and attorney filed the appeal, and he had.
Oh, okay. I think you have a good case. Well, because heavy construction, and if you have decent medical records and you've been really good about getting treatment, Wes, you're probably going to be shown that you can't do your prior work. And depending on I forget what your stuff is.
Yeah, he's got back problems.
Then it could very well bump him down below medium. All you need to do is be below medium. And heavy construction and heavy equipment operator or even small equipment, I suspect those are non-transferable skills. I know a CDL is non-transferable. There's an SSA rate up on that.
He's got that he uses a walker and cane interchangeably.
Yeah, which that wouldn't even be needed for a grid out if it just shows he can't do medium work.
Yeah. He's got a very decent chance if all the medical records are sent in and, like they're supposed to be.
Yeah, I bet you. And, going back to it, Wes, even though you don't like the communication or lack thereof with your attorney has every incentive to prevail for you, or else he or she doesn't get paid. So there's always that. And they're probably doing things that you didn't do or have or submit on initial. And it's going to make a big difference. I mean, you might go to ALJ. We've been getting quite a few recon, switcheroos. Shannon and I have talked about this before, guys, that when you actually do work and change things and submit things and show the dynamics of your situation through initial and recon, you can win on initial and recon. It's a matter of not just sitting there and waiting for a result based on what you filed on. And some attorneys, take steps during initial and recon and non-attorney reps, like Shanna and I do, and some don't. It's not part of their practice. They file and they see where it goes. But there's a lot you can do, and I bet you, I wouldn't be surprised if your lawyer is maybe doing it behind the scenes. Maybe he's seen something different. He saw maybe what medical records. Maybe they didn't even have all your medical records on initial. So Sunflower says, what happens if your mental health provider doesn't send the records for your treatments? Records requested but not sent. It's the only thing missing. Yeah, didn't we just talk about this?
Yeah.
Oh, I'm repeating. That's because I floated back up. Let me see. Going down to. All right, I'm back on track here. So when I scroll up, I lose my spot. Sunflower says, if you push through medical and mental health conditions until your mental health and medical conditions didn't allow you any longer, will this make it harder to win strong work history? I don't think so. I think that's really good.
It usually helps, yeah, because they see that you would rather be working if you could.
Right. I mean, if you're a person with a weak work history, it doesn't mean you're not disabled, but you certainly don't have the proof to show that you would be working if you could. It's an added, right? It's an optics, really. Oh, RD has a 10-pound lifting restriction. Also, tailbone pain sitting. Oh, I had that coccydynia myself. Probably related to something different than you, but it made sitting hard. In fact, I still have my donut, and I'm sitting on it. You would have thought I was a roofer. You're so funny. Yeah, but that gets you below medium for sure. It actually gets you below light, too. So I think you have a really, really good chance, RD.
Yeah.
You're welcome, Sunflower. She says, thank you, ladies. This is so helpful. All right. Wes. Reconsideration stage 3. Yeah. You know, you can get, just because your lawyer doesn't reach out to you if he doesn't need you, doesn't mean you could still reach out to him to tell him about stuff like that.
Yeah, make sure they got all your recent medical treatment, medical providers, all that stuff, so that they can let Social Security know and get your records sent to them and make sure they've got everything. Because you definitely, with your age and everything, have a very good chance of getting it at reconsideration this time. But you just got to make sure that they have everything.
Now, this is interesting. So Wes points out that he has 1,500 pages. It almost doesn't matter unless you only have 5. You can have 500 pages and it can be very stellar. You can have 10,000 pages and it can be crap. So it really depends. It's the quality, not the quantity. Frequency of visits to at least a minimum level of reasonableness is important because that goes towards severity and all that business. Generally, anyway. Yeah, well, the process is flawed. Yeah, I understand, Wes, because you know what? Not everyone knows the rules. I get it. Like, it's not like every claimant goes in there and has a full encyclopedia in their brain of all the rules and what they need to do to prove, and therefore they don't provide all the things they need because they don't know they need them. That, of course, you got smart though. You got a lawyer. I think you're going to be, or not attorney rep, it doesn't matter. I think it's going to make a big difference. Whether it does it on recon or not is difficult because of, the quasi perception that recon is a rubber stamp. But it can flip on recon, but it really often depends on the adjudicator too. So you could have your attorney flipping things so differently and they're just going to rubber stamp it. And then sometimes you get one that doesn't. So, but then you have an ALJ, and that's where the whole ball game changes, because now you have someone with discretion who can read between the lines. And if it's there, it doesn't have to be so much check boxes with an ALJ.
Sometimes it just has to go to the judge.
Yeah. Okay. I think we're good. We've gone 2 hours and 16 minutes. Shanna, thanks for sticking it out. It was great.
I like doing it with you.
It is. It's fun. And everybody's so sweet. I honestly have, it's one of my favorite days of the week coming here. So anyway, I will see you guys I was trying to get the replays up of this by Thursday, and I will let it go up just au natural. But then what I'm trying to do, Shanna, is put it through this software that takes out this is usually when I'm alone, this happens most, when I'm reading and I'm quiet, like on a replay, nobody needs to be sitting there. Like, it's different when you're all live and we're all chit-chatting, people are chatting, but on a replay it doesn't work so well. It's just not friendly. So I'm trying to run it through that, so it's like an auto thing. It takes those pauses out, but it takes, because it's a couple hours. I find that sometimes it's not happening where I can even post it by Thursday. So, but I will have it up by Saturday then.
Well, you're more tech savvy than me. I want to learn your trick.
I just play until I learn it. I'm like a dog with a bone. I've got a bunch of things I'm playing with right now, and I'm like, oh my God, I'm so stupid. I need a youngster in here who can do all this, but no one has time. So anyway, but it will be up Saturday, so anyone can come in, and it'll be a little bit shorter anyway, without all the pauses. And then I just put it up there, and I don't put it up Friday because I do that Friday fraud law review where I put out one of the OIG's fraud convictions, or sometimes it's indictments, but usually it's gone all the way to conviction and or sentencing. And I love to put them out there so people can be very well aware that, yes, indeed, we have fraud.
Yeah.
And quite a bit of it. And it's very expensive. So that's my Friday. So, but all right, I will chat with you later. I'll close these guys down, but Shanna, stick around.
All right. Thanks for having me, though.
Bye, guys. Hopefully I'll see you at 9 o'clock. If anybody who's still listening, I was thinking of changing the 9 a.m. to something more like 10 or 11 a.m. What do you think? The videos in the morning, a different time frame. These are not live, Shanna. These are just like ones. Just a thought. I just want to know what you guys think. I know 9 a.m. is good for East Coasters, probably most of them, but people probably watch them after the fact anyways. But California people might be like way later, and then it's, I don't know. Just a wonder. I was thinking 10, 11, 12, maybe change the time frame. I don't know. I'd like to know what my East Coasters think. All right. I'm going to turn you guys off, and I'll turn back to Shanna. Bye, guys.